So basically, we started with the basic introduction of CRPC, which included the history and interpretation and everything. This is where we have started. Then we moved on to the kinds of courts for criminal trial, their powers, and their powers included submission, committal, and making over. Powers included power to try and power to. So this was the first topic we did. We skipped the composition of codes because that is not important from the point of view of examination per se. So we skipped that. Then we jumped to the investigation part. So what happens? Let's understand it from here. Suppose an offense is committed. We all know the person goes to the police station. Police station lodge, the police officer lodges an FIR if it is a cognizable case. I'm talking about a cognizable case only here now. Then the investigation starts. Then a police report is filed. Yes, Simran. Then a police report is filed. And then cognizance is take. Guys, please. Okay, I've lost it. Yes, I've lost it. I have made it. The whiteboard is only accessible to me now. Nobody can write it because of obvious reasons. So don't do this, guys. This will disrupt the flow, and we all are, we are not school students. You are not school students. So now I was talking about the very so the whole structure of the classes we have went through. We have done the history and introduction. We have done the powers of the courts, the powers to try and power to punish, then including submission, committal, and making over. Then comes the investigation where we are now. Before investigation, it was important to explain what is cognizance and what are the cognizable and non-cognizable offenses. So I was trying to explain once an offense is committed, the FIR is filed in case of a cognizable offense. Then the investigation begins. As soon as the investigation begins and then the investigation ends, the police file a police report. That means the charge sheet in front of a magistrate. Then the magistrate on that charge sheet or the police report take cognizance of an offense, which is the clause. Which is the clause on which the magistrate takes cognizance on a police report?
121B.
Very good. So then the magistrate takes cognizance, then the issue of process happens, then documents are given, then charges are framed. Till here, this is inquiry. And after this is trial. After charges are framed, the examination of witnesses happens, then cross-examination happens, sometimes re-examination happens, appreciation of evidences happens, then the judgment is pronounced. Then if there is an appeal on the judgment, then it is a continuation of the trial only. So this is an elaborated form of the trial. Investigation is this. This is whole investigation in case of a cognizable offense. What happens in a non-cognizable offense? As soon as the offense is committed,
A non-cognizable report is filed.
so person runs to the police station. The police records a non-cognizable report. Then police sends it for approval, sends for permission to a magistrate. And if the magistrate says no, then there is end to the proceedings. If the magistrate says yes and directs investigation, then the investigation starts. And then the investigation continues. The police report is filed, because after, if the police officers are doing investigations according to chapter 13 of BNSS, then a police report will definitely come into the picture, because no investigation can be completed without filing the charge sheet. The charge sheet is compulsory. So as soon as the charge sheet is filed, then cognizance is taken, and then everything is similar. Inquiry begins. The whole inquiry is completed as soon as the charges are framed, the trial begins. So this is the whole process for investigation in a non-cognizable offense. In a complaint case, if a complaint is made directly to a magistrate, the magistrate directly take cognizance on complaint. Please answer. Come on, please answer, guys.
A. Ma'am, 1A.
Yes. The the magistrate takes direct cognizance of a complaint because of 210A. Now, can somebody tell me whether the magistrate can order investigation or not? If this is the case, then if the direct cognizance is taken, then the direct issue of process happens, calling of accused and witnesses, then direct documents are given, charges are framed. That's it. This is the complaint proceedings. Before this, complaint proceedings happen, which is different from investigation. This is chapter 16 proceedings. This is totally different. This is a kind of investigation only, although, like, the magistrate directs the police officer or any other person to do the investigation, that whether the complaint is valid or not. And then if the complaint is dismissed, then nothing happens. If the complaint is approved, then the witnesses are called and the accused is called, or the accused are called. So where if this is the scenario, then there should not be any kind of investigation and there should not be any kind of police involved in complaint cases. But this is not the thing. The police can direct complaint cases also the investigation here. Somewhere between getting a complaint and taking cognizance, the police can be directed to investigate the case. And if the case is investigated, what did I tell? If the case is investigated, this is a may provision. We'll read the sections. This is a may provision. Okay, so it depends upon the magistrate to direct the investigation or not. This is not a compulsory investigation because a complaint case is directly going to a magistrate under 210(1)(a). So if it is directly going to magistrate, magistrate may or may not think that investigation is necessary under chapter 13. If it is directing investigation under chapter 13 of BNSS, then cognizance will not be taken 210(1)(a). Cognizance will be taken on a police report. So it will be 210(1)(b). This is a case where a complaint case is converted into police report. Is this my laptop's fault? Okay. Complaint case is converted into a police report case. So the magistrate will take cognizance on a police report and not on a complaint. Because the trials are different, that is why we are differentiating. When we'll come to trials, the procedure for trials, because we are abhi in the process of investigation, we are going to elaborate the investigation wala. Just understand this line is going to be elaborated for now. Cognizance is already elaborated. Then we'll be elaborating the inquiry proceedings and then we'll be coming to the trial proceedings. So the whole procedural code of CRPC or now BNSS is divided into these three parts: investigation, inquiry, and trial. So we are dealing with investigation for now. So investigation, if investigation under chapter 12, under chapter 13 is taking place, then the police report will always be filed and it will be converted into a cognizance taken on a police report case. Now, what happens in case of information? Information cases. Information cases means 210, I'm talking about 210(1)(c), where the magistrate receives any information from any other person apart from the police officer, or suo motu takes the cognizance. He receives the information, he directly takes the cognizance. Then the same things happen: issue of process, documents, charges, and then the trial begins. Charges framing, and then the trial begins. Now, here, in such cases, the magistrate can again order investigation under chapter 13. This will again be converted into a police report case. And the magistrate will take cognizance before, because the magistrate is ordering the investigation before cognizance, so magistrate will take cognizance on the police report under 210(1)(b), and the trial will continue as a police report trial and not as a complaint case or otherwise than a police report trial, because the proceedings are different. Clear? So basic meaning of investigation is collection of evidences. You can read the definition after the class from section. The new section is basically nobody's asking you the section, but I'm just telling you so that you can read it. 21L. 21L, which mentions the new Bear Acts is 21L, the old is 2H. 21L, which is collection of evidences. By a police officer or any other person except magistrate. Magistrate can direct the investigation. Magistrate can order for investigation. Magistrate can supervise the investigation. We'll see some instances, and we'll see when we'll read the sections for procedures of investigation for cognizable and non-cognizable offenses. We'll see that the magistrate can supervise the investigations, but magistrate himself cannot go and do the investigation. Reason behind that is not that magistrate is a superior authority and investigation is a task where magistrate, why magistrate will go. Reason is not that, like one of the reasons is that also, but the primary reason is that magistrate, if he is doing the investigation himself, he'll be biased in the trial. Obviously, if he'll do the investigation, he'll frame a case against someone and he'll be biased towards the other person. This happens usually. The police officer is biased towards the prosecution, and he is also called as a witness in the witness box. The IO is also, the veracity of IO is also tested in the court. The investigating officer, IO is the investigating officer. So anybody can conduct the investigation. This is the broad meaning which you have to remember. Other than the court, other than the authority of the court, anybody can do the investigation. Clear till here? Any doubts? Go ahead.
Ma'am, which was the section 21L?
21L of the new law.
Okay.
Anybody who's authorized by the magistrate can do the investigation, but not the magistrate. Then inquiry, and then the trial. So surprisingly, trial is not defined anywhere in the code. You need to understand the meaning of the trial apart from the definitions of the code. But inquiry is defined in the code. But that is, the definition is also very vague, and that has not been even elaborated by the new law, the new BNSS. It is exactly same which the CRPC provided. Inquiry is something which is not a trial, and it has to be conducted by a magistrate or a court. That's all. That is the whole point which is mentioned under the BNSS also. 21K is the inquiry, its definition. Why I'm explaining inquiry now? Because there are a lot of instances where the magistrate is going to order for inquiry when the investigation is not sufficient according to the magistrate. So why I'm explaining inquiry for now, this is the reason. I'll not be going into trial. Like, I'm just going to tell you from where the trial begins, and when we'll be going through the trial proceedings, we'll understand the trial in detail. Where trial is not even defined in the code. So inquiry is something which is done by the magistrate or the court, and it is not a trial. That's all. That this is the whole meaning which is mentioned under the BNSS also. Now we have to understand where inquiry starts and where it is finished. Why inquiry starts? Inquiry starts because before actually commencing the trial, a magistrate or the court has to be very confident that yes, this is something where we can, like, this is a foolproof case, just to put a check upon the police investigation. There are a lot of provisions, and the whole code, the whole chapter 13 depends upon checking the power of the police, so that the police officers do not cross their limits, or police officers do not cross their powers. Just because of the fact that, this was the practice even before the partition. That is why the old CRPC was adopted from the 1974 CRPC was adopted before partition, and that was the replica of the old CRPC. I think that was 1864 or 1874 CRPC, the older one. So that was before partition. No need to remember the year. Just remember that the before partition CRPC, before partition as in 1947, even in the rule British era, police officers used their powers in, you can say, not in an appropriate sense. So that is why the old CRPC was framed, and then the new CRPC was also the replica of the old CRPC, apart from the few changes. And now also you can call the new 2023 Act as a replica of the old 1974 CRPC with some few changes. So inquiry generally is where inquiry ends, the trial begins. But the trial is also conducted by the court, and the inquiry is also conducted by the court. So there are some instances where the trial and inquiry can overlap. But it is always important to understand that where the overlapping can take place, FIR or complaint or information or NCR, whatever is the situation, if the investigation takes place or not, whatever is the situation, if the cognizance is taken, then the inquiry will happen. This issue of process and then giving the documents are a process of inquiry. So the court will do the preliminary inquiry, then call the relevant persons, and then give them the documents. And then the charges are framed. In some, as I told you, there are different kinds of trial also. In some of the trials, for example, in a full-fledged trial on a police report, there is a provision for discharging the accused here. Somewhere here. Discharging the accused. Discharging the accused means, if even after giving the documents, if the court thinks that there is no sufficient evidence before framing the charges, if the court thinks that there is no sufficient evidences to even frame the charges against the accused can be discharged. Discharge means then there can be any second proceedings against the accused. For example, if A has committed a crime and there are no sufficient evidences, but the court has taken cognizance for, for basically on the basis of some prima facie evidences. And then the court calls the accused and the witnesses, give them the documents, conduct the preliminary inquiry, and then the court feels before framing the charges that there are no sufficient evidences to even frame a perfect charge against the accused. There is no case. The case has not even been framed. Then the court can discharge the accused. if A has been discharged, then A can be called again. Okay. If then again after some time there are some facts which are disclosed later on, the court can call the person, the A was the person, the court can call A again for the trial and begin the trial from here. Charge framing. It is different from acquittal because after charge framing the whole trial begins, and after judgment, if the person is acquitted as in
Ma'am, there is no case against him that he is innocent.
yes, from punishment.
Ma'am,
Yes.
I have a doubt. Ma'am, when you said that when you discharge an accused, there cannot be any second proceeding against the accused, does it mean like if the court brings up the case again, it is fine, like you mentioned right now?
If the person is discharged, first of all, there can be a proceeding against the accused. Can be, not cannot be. Here the proceedings cannot be second proceedings, and anybody can file, anybody after some disclosing of, like for example, a person is acquitted or a person is discharged on the basis of not sufficient evidences. The benefit of doubt is always given to the accused normally, but if that is the case, then the accused is discharged, and if there were not sufficient evidences, if the accused was discharged, then if the court thinks after maybe after 6 months that there are new discovery of evidences, even a person can bring that, or even a magistrate can take cognizance under on his own information. So the proceedings can be reopened. That is the whole point of me explaining discharge. And then acquittal, if a
Ma'am,
person
so can the same party bring it up again?
the same party, the other party, X, Y, Z, anyone can bring the new facts and file an FIR again if it is under the limitation period.
Ma'am, I have a doubt. Ma'am, how this concept is different from Section 319 of CRPC that allows the court to proceed against any person who is not even an accused in the case. Sir, ma'am, just like in this, if the person gets acquitted, so can he be brought again to the court under Section 319 or like old one from old CRPC? Ma'am, I have a doubt regarding this.
If a person is acquitted, the person can never be brought again in front of the court. Virtue of Section 300 of old CRPC, which says a person once acquitted cannot be never called again in the court. This is a fundamental right under Constitution also. I think it is 21, Article 21. Nobody can be punished twice. So,
No, ma'am, I think it's Article 20, right? Double jeopardy.
what 120 article?
No, ma'am, Article 20, double jeopardy.
Yes, that is what I wrote. 20.
Okay.
20. 20 clause 1. So this is 20 only. Article 20, double jeopardy. So this is if in the case of acquittal, nobody can be called. I think who asked the doubt? Sayak was it? Siddhant.
It was me,
Sure.
Rishabh.
Okay. So Rishabh, in case of acquittal, you use the word acquittal by mistake. I got the point that you are asking about discharge and 319.
Yes,
Right?
ma'am.
Yes. So in case of discharge, the only accused can be called twice who was discharged before framing the charges. Under Section 319, the stage is different. So there is a lot of difference between discharge and 319. Okay. So just understand for now, discharge is something very different. This happens before framing of charges. So why I'm explaining this for now? Because before framing of charges, anything that happens after cognizance is an inquiry. So hearing on charges and discharging an accused is an inquiry and not a trial. If such a kind of illustration comes in your exam where the accused is discharged, and then the question is, the paragraph says the accused was discharged, and then there was a question out of the paragraph that whether the accused was discharged, was it the trial or a part of a trial or investigation or inquiry? Clearly, it is not an investigation because the court is discharging the accused. But you guys can be confused between inquiry and trial, so that is an inquiry and not a trial.
Ma'am, one doubt. So what about appeal cases after acquittal?
Appeal, apart from the appeal. This is apart from the appeal. Appeal is filed by the opposite party, right? This is,
Yes, ma'am.
that is different. Apart from the appeal is not an exception of acquittal, like this, the section 300 or article 20 clause 1. A person once acquitted in a court, in the same court, you can say, cannot be called twice. Appeal always happens inferior to superior.
Okay, ma'am. And also another doubt, since you mentioned regarding documents submitted before framing of charges, is that what you said yesterday with regards to the FIR, copy of FIR submitted to the
No.
accused at a later stage?
No, that is not mentioned like anywhere in the code. That has come from the ruling of law. Like one of the Supreme Court's cases, that has come from one of the Supreme Court's cases, and not the law says it. The law is silent, like the procedural code or the BNSS is still silent that whether the copy of the FIR should be given to the accused before taking cognizance of the offense. Okay, so now let's understand the inquiry. FIR is filed or whatever form of information is received. If the police report is filed and then the cognizance is taken, if the police report is filed and then the cognizance is taken, then whatever happens between cognizance and charges is inquiry. Charges as in the framing of charges, not the hearing of charges. And once the charges are framed, the trial begins. So you can write that charges, the framing of charges is a gateway to trial. Framing of charges is a gateway to trial. Now, since between FIR and police report, this is clearly investigation. This is inquiry and this is trial. So what is this between police report and cognizance? I told you before taking cognizance also some kind of questions are, for example, in the case of Nupur Talwar, there was a lot of ifs and buts before taking cognizance that whether we should take cognizance or not. In case of Harish Chandra, also the evidences which were brought before the court on the basis of the police report were not sufficient to take cognizance. So what are those proceedings where the court thinks that whether the evidences are sufficient or not to take cognizance? This is deemed inquiry. Deemed inquiry. This is also nowhere mentioned in the code, but yes. Okay, so I'm repeating the concept of discharge again. So there are two things. If the trial goes on, for example, everything goes on successfully, the FIR is filed, the police report is submitted to the magistrate, the cognizance is taken over, then the inquiry happens, the charges are framed, the whole trial goes on, the judgment is pronounced, and then the court thinks the person is acquitted. Free. No punishment. Because it went through the whole trial, that is why if the acquittal happens, the person cannot be called again for the same offense in the same court. Cannot be called again. In case of discharge, the court, under some of the full-fledged trials, the power of discharging the accused is not there in some shortcut trials. For example, if a court is trying an offense in a summary manner, there are some offenses which have to be tried out summarily, just because owing to the situation which the country is in currently, there are a lot of pending cases. So the position of summary trial is very high in the uh, you know recent era. So if the cases are being tried summarily, there is no provision of discharging, there is nothing like charges framing also. So the summary trial is altogether different. But in a full-fledged trial, if the charges, before framing of the charges, somewhere here the inquiry is going on, and between somewhere here, before framing the charges, if the magistrate thinks that there is no case against the accused only, how can I frame the charges? The accused is discharged. Discharged means free from charges. Free from charges, but this is not acquittal. The person can be called again if there are new discovery of facts. The facts can be discovered from wherever the court thinks fit. If the person should be called again, the person will be called again. Dismissal is the dismissal of complaint. If you see the provisions of CRPC or the BNSS, dismissal is only used when the first of all, the complaint is dismissed. In a case of complaint, complaint is given to the magistrate, cognizance is taken by the magistrate, then the persons are called, the documents are given. But before this, the magistrate commences a sort of inquiry under chapter. It is 16 now. Yes, it is complaint proceedings. We call it complaint proceedings. So complaint proceedings, if after doing the complaint proceedings, because there is no mandatory provision of investigation here. So what if the investigation is not conducted and there is nothing to test the veracity of a complaint? There is nothing to test even whether the complaint was genuine or not. The court will waste so much of time calling the person, giving them the documents, then framing the charges. Even if not the framing of charges, then discharge will happen. So all those things will happen. The court will waste a lot of time. So to prevent that wasting of time, chapter 16 is there and the complaint proceedings will happen. If the complaint proceedings happen and the court thinks that no, the complaint has to be dismissed, so the case is dismissed. That's all. The accused is not even called. There is no such thing as discharged or acquittal. Then the second dismissal is on FIR also. We are going to study it today. On FIR, if after investigation, usually what happens? The police report is filed. But in between, if the police conducting the investigation thinks that there is no case at all after investigation, then the police files, or there is no sufficient evidence against the accused, then the police file the closure report. As I told you in the Nupur Talwar case, the Arushi Talwar double murder case, then against this closure report, a protest petition can be filed. Protest petition means what? To protest the closure report, that no, the closure report should not be filed. There is a case against the accused, because someone who has lost his property or a person near or dear, he will definitely want the case to be conducted, the trial to be conducted. So a protest petition will be filed, and against this protest petition, the hearing will be done, and then this hearing will be either dismissed or accepted. So this is dismissal. There is no question of acquittal or discharge here. This is all about inquiry, investigation, and trial. I just want to clear one thing, that if the complaint is dismissed here, and then no trial takes place, because in complaint cases, not even investigation is taking place mandatorily. If the magistrate does not order investigation here, and only the complaint is presented to a magistrate, cognizance is taken, even if the complaint proceedings happen, issue of process happen, documents are given to the persons, charges are framed, then the trial commences. Very well. Okay, then it is a full-fledged trial. But what if before this chapter 16 like before issue of process, if chapter 16 results into dismissal of complaint, if the magistrate thinks that there is no ground for even filing a complaint, then this is a case of only inquiry, dismissal of complaint in a complaint case. This is not even not happening anywhere, like only in complaint cases this is happening. And then the other instance of only inquiry is on information cases. On information cases, the same thing happens, that information is received, direct cognizance is taken, then between here, if the inquiry happens and the court thinks that this is not a case, the court will not go on with the trial, and this becomes the only inquiry case if the investigation is not directed. It depends upon the discretion of the magistrate. Third instance of only inquiry is discharge of accused, where even before framing of charges, from here the inquiry begins, where before framing of charges, here the accused is discharged, then obviously the charges are not framed, then no trial. This is the only, okay, not in the case of FIR, but in cases of complaint. Because complaint directly cognizance is taken. So in this case, no trial is there, no investigation is there, then this is the only case of inquiry. So only these three instances are possible where there is only inquiry, no trial, no investigation, and no such case is possible where only investigation takes place. Only investigation and only trial not possible. Why? Because if investigation takes place, there has to be a police report or there has to be a closure report. If there is a closure report, the court is going to direct the inquiry. Then the inquiry will take place. If there is no investigation, no complaint, nothing, then the trial will not commence and there can never be an instance of only trial. Deemed inquiry is between FIR is filed, police report is submitted. This is investigation, right? After police report, cognizance is taken and then the inquiry begins. And then charges are framed. Here trial begins. This is, if this is inquiry, this is trial, this is investigation. Wait. If this is inquiry, if this is investigation, sorry, and this is inquiry, and this is trial, then what is this? This is left in vacuum and nothing can be left in vacuum. This is deemed inquiry. This is also a part of inquiry. Between police report and cognizance, if the magistrate, for example, the perfect case is Nupur Talwar, where the after police report by the team number 1, there were no sufficient evidences and like the evidences produced before the magistrate were very confusing and the magistrate was himself confused whether to take cognizance or not. So this whether to take cognizance or not, appreciation of evidences, all the things are deemed inquiry. A part of inquiry. Deemed inquiry means which is considered to be an inquiry. Deemed inquiry. Not actually an inquiry, but it is also considered to be a part of inquiry. So we are going to study inquiry and trial in detail, but for now we are studying procedures between this, which is a part of investigation. Or in case of non-cognizable offense, if accepted by magistrate, magistrate will direct the investigation and then the police report will be filed. So then this is investigation. So this is the overview or a broader view what we are doing right now so that you guys are not confused as to the broader picture of CRPC. Is there any difference between inquiry and inquiry under this procedural law? Not as such, but the spelling which is used in the code from very inception is INQURY. It is that only. If you see the dictionary meaning, it is very similar. You consider this like to never write it ENQIRY, always write it inquiry, because this is actually what is mentioned in the Bear Act. Okay, now let's start with FIR. Yesterday we covered NCR, non-cognizable report, and the procedure thereof. Non-cognizable report has to be submitted before the magistrate for permission, and then the investigation is directed by the magistrate. And then the last clause was whether if one, come on, I want answer, like I'm going to explain the clause 4, no need to remember the section, just if one case is cognizable and the other case is non-cognizable, what will be the case considered?
Cognizable, ma'am.
Yes. It is the last clause of the non-cognizable reports section. Now let's quickly come to 173, which is FIR. This is only one section which you have to remember the number of the section from the whole chapter 12, or maybe one or two sections more. Nothing like, no more provisions you have to remember apart from these provisions. 173 is very important from the point of view of new law. I've opened BSA today. BSA is the Bharatiya Sakshi Adhiniyam also, because we are going to come across a lot of provisions of BSA. Because again, to put a check upon the powers of police officer, the statements made during the investigation are not even considered to be an evidence sometimes. So that is why Indian Evidence Act is important from the point of view of today's lecture. So this is 173. Information in cognizable cases. Okay, this is like some things are changed here. So look at the screen, and those who have old Bear Acts, and keep marking on your Bear Act whatever is changed. Every information relating to the commission of a cognizable offense. Cognizable offenses are provided under Schedule 1, and cognizable offenses are those where the police officer can arrest without warrant. Without warrant, the arrest can happen. Irrespective of the area where the offense is committed. This is something new. This is called zero FIR. The jurisdiction clause, the limits of police station, the limits of the procedure is different. The procedure for investigation is different. The procedure for investigation should be within the area. There is a restriction of area. If you see the section number 175, or if you are opening the old Bear Act, it is 156. If you'll see that section, there is a limit of area. The procedure is different, but we are only talking about FIR. If a person goes to the court, if a person goes to the police station with some information of an offense, that the offense is committed in Nagpur, and the person is going to Mumbai, filing the FIR there, the Mumbai police station cannot refuse to lodge the FIR now after 2023. Before 2023, the police will definitely tell them to go back to Nagpur. तब तक बहुत कुछ हो जाता है. You also know that. So that is why, to again control the powers of police and to not to let them misuse their powers, the restriction of area is removed. Clear? Till here? Then I'll move ahead, because this is one of the areas where the questions can be very easily framed. Mumbai, Pune, Nagpur, Nasik, Udaipur, Jaipur, any example they can give. Maybe they can give two areas, X area, Y area, where there are two other police stations. The jurisdiction of police A is X. To confuse you more, they can give anything, any such illustrations. Please remember, FIR can be filed after 2023 anywhere. Now, FIR can only be filed in case of cognizable cases. The police will record the FIR only in cognizable cases, irrespective of the area where the offense is committed. In India, obviously. Maybe given orally or by electronic communication. This includes emails, WhatsApp, or any other form of communication you can imagine. No specified form is mentioned here. So even if a person drops a text message which nobody sees these days, the information is transmitted. If the information is given orally, it shall be reduced into writing. The police officer is bound to reduce the information if it is given orally in writing or under his direction and be read over to the informant, and every such information, whether given in writing or reduced to writing, shall be signed by the person giving it. Why signed? Because then only he can be called as a prosecution witness in the court. From where the offense begin, from where the proceedings begin, in cognizable cases, it is FIR. If FIR, the person who's filing the FIR is not even coming to the court, how the trial will be proceeding and how the court will be able to figure out whether the information was right or not. He is a person who has seen or heard, or the first informant, who is very important. So he is one of the very credible prosecution witness. Prosecution, I think it is clear, one party is prosecution and the other party is defense. Civil cases, prosecution and defense. Criminal cases, prosecution and defense. Civil cases, plaintiff and defendant. We are reading criminal law, so that is why prosecution witnesses and defense witnesses. By electronic communication, it shall be taken on record by him on being signed within 3 days. Very important. 3 days. This limit is very important. If the information is given through WhatsApp, suppose WhatsApp, there are a lot of, public police numbers now available on the internet and available, like the news flashes that please inform us if you have any problem, inform us if you see any offense being committed. If I WhatsApp a police station nearby to my house, that, like, with the whole description that I saw a killing bee with a knife in his kitchen when I went to their house for a party. This is at 10 p.m. today. This is the whole description. The description is enough, and I am Mahima. I go and tell this, and I live at XYZ place. This is all I WhatsApp to a police station. And then the police number, the police calls me back, ask me to come to the police station, sign the copy, or they will be, even though if after the execution of these laws, like as soon as the laws will be executed, there will be a medium of providing if the person cannot come to the police station, like if I cannot go to the police station, so there'll be a medium of, providing me the electronic document through mail, and 3 days, because the copy should be signed within 3 days. So within 3 days, the copy should be signed, and then I'll be called as a prosecution witness in the court. Ma'am, so in which case territorial jurisdiction is considered non-cognizable offense, ma'am? 0 FIR, not okay. Anju, in non-cognizable offenses, there is no FIR. In non-cognizable offenses, there is non-cognizable report. FIR can only be in the cognizable cases. For non-cognizable reports, we studied it yesterday, there is a limit of jurisdiction. The offense should be committed within the limits of a police station only. So suppose if a smaller offense, let me just give you an example. This is clear? FIR is clear? Like till here, is this clear till clause 1? Yes, Parvez.
Ma'am, so in this case, what if I send them every detail over WhatsApp, but just everything except my name?
It will not be accepted. Anonymous FIR is not an FIR. They'll ask your name. They'll call back.
All right. Oh, ma'am, another doubt. What if I also get killed in the example that you gave with the friend in the kitchen? Let's say I call the police station, I give them the information, and by the time they get there, the whoever just kills me as well.
It'll be a dying declaration under
Alright.
Section 32 of Indian Evidence Act. The new section is, I think, 27, if I'm not wrong. The
Alright.
BSC. So basically, what happens is if a person calls the police and tells them immediately before his death that save me, or this is happening, and then the police will come to your house, obviously, and you are also killed. It will be a dying declaration by you. And yes, in case of anonymous FIRs, the police may go, considering the seriousness of the call or considering the seriousness of the WhatsApp message, they'll call you back, obviously, and they'll try to understand the whole, unfold the whole situation. They'll go to the location, but then that will not be an FIR. That will be a case of information.
Alright.
210(1)(c). Addressing Anju's doubt now, in case of a non-cognizable offense. For example, two persons are fighting on the road. I go to the police station and I tell them A and B are fighting on the road and they are drunk. This is causing disturbance to the public. And they daily come here and fight a lot. So please do something. This is obviously not a serious offense. This is not a cognizable offense. I think this is AFRE and this is a non-cognizable offense. So if it is a non-cognizable offense, police will file the non-cognizable report. This is different from FIR. Then the police will send it to magistrate. Magistrate will ask to investigate. Investigation will be done in, I think, 1 or 2 days, because this is very small. They will go to, usually they'll go to A and B's home and they'll try to explain them, don't do this. And if they keep on doing this, see, this is a very small case, right? There is no such investigation is required where the persons are called, the persons are examined, the statements are recorded, the confessions are made, and then the trial begins, the charges are framed. These kind of offenses are summarily tried. These kind of offenses, the court not even framing charges, just give them some monetary punishment, whatever is mentioned, or some imprisonment of few months, simple imprisonment, whatever is mentioned in the BNS or IPC now, let them go. But if this offense happens, suppose I live in Karol Bagh, and the offense, the fighting is happening on Rajiv Chowk metro station regularly. The outside the metro station, the A and B are fighting a lot. I go to the police station of, like, I go back to my home and I go to the police station of Karol Bagh, because that is the place where I live. The Karol Bagh police will tell me to go back to this Rajiv Chowk metro station, because the jurisdictions are different. Like, I'm just giving you an example. I don't know whether the jurisdictions are different of Karol Bagh and Rajiv Chowk metro station. Police stations jurisdiction are different. Courts jurisdictions are different. That I know. Consider it XY, X area and Y area. So non-cognizable offenses, there is a limit of jurisdiction. For cognizable offenses, the limit of jurisdiction is removed. Ma'am, what if the information is that A is killing B? No, that is not an FIR. Again, the police will go and see whether whether the information is right or not, but that will not be an FIR. We are talking about FIR. Now, if this happens, if the information is given orally, it is reduced to writing. If the information is given through electronic communication, it is signed, and the information is also signed in case of manual information, then the substance shall be entered in a book to be kept daily. A book should be maintained in case of non-cognizable offences also, and a book should be maintained in cognizable offences also by the police officers, in such form as the state government may prescribe. This is all about it. The only important provisions were for FIR that the removal of jurisdiction is there, and 3 days for electronic communication, signing of the FIR, and every FIR should be signed by the informant. Then only it will be a valid FIR. Proviso, provided that if the information is given by a woman against whom an offense under these sections of BNS, this is an extra section which is which was not a part of older CRPC or older BNS, because this is, I told you in one of the classes that 69 is an added offense under BNS, which punishes a man, like in a broader sense. We'll study BNS in detail and we'll understand it. Which punishes a man if he commits any false promise of marriage and then he commits the sexual intercourse with a woman. So if it is proved, a lot of circumstantial evidences are required to prove that sort of offense. If it is done and if it is proved in the eyes of law, then under section 69, the man will be punished. It is only against a man. So this is an added section. If all these sort of information is made by a woman against any person, and then such information shall be recorded by a woman police officer or any woman officer. Any woman officer can record it. This is not a requirement that the woman should be a police officer. Any women officer. There are more parts to this sexual offences proviso. In the event that the person against whom an offense under section 64, 65 and all these provisions is committed or is alleged to be attempted to be committed is temporarily or permanently mentally or physically disabled, the victim is permanently or temporarily, mentally or physically disabled. Even mentally disabled, physically disabled, whether temporary or permanent disabled, then such information shall be recorded by a police officer at the residence of the person seeking to report such offense, or at a convenient place of such person's choice in the presence of an interpreter or a special educator, as the case may be. The recording of such information shall be videographed. The police officer shall get the statement of the person recorded by a magistrate under clause A of subsection 6 of 183 as soon as possible. Now, what is 183? We are going to study it tomorrow because it is important. 183 is basically, I told you that we are covering this for now till police report, the investigation part. So this investigation part, somewhere here, the magistrate, usually the investigation is conducted by the police officers only. But the magistrate also takes part, like he is not doing the investigation, but the magistrate asks for the confessions by the accused. This happens after the police's examinations and everything the police is required to do to seek a confession. Then the magistrate talks to the person. This is the broader meaning of 183. So 180, under 183, this is 164 if you talk about the older laws. So if you see 183, subclause A of subsection 6, a lot of changes are there in 183 also. So what it is actually stating is about the rape sections only, or the offenses against women only. So if all these offenses are alleged to be committed or attempted, then the statements under 183 should be conducted as soon as possible. This was the exact language in the old law also. This is the exact language in the new law also. So no time limit is mentioned here. Just it is mentioned that if it is such a kind of offense, which the offenses which are mentioned here, the list of offenses, then the police officer should do it as soon as possible. The police officer should produce the magistrate, the accused before the magistrate, and the police officer should ask for the confessions. Any doubts? No doubts. As if nothing is clear, I think, if there is no doubt. Is it
Yes,
clear?
ma'am. No doubts. No doubts, ma'am.
Okay. So this is FIR first part. FIR second and third part is a little tricky. This was easy. This is little tricky. A copy of the information as recorded under subsection 1 shall be forthwith, immediately, without delay. Again, no time limit. Free of cost provided to the informant or the victim. This is a new word here, victim. In the old law, there was only informant. Informant as in the person who is giving the information. Usko hi FIR milegi. As I told you, the law is silent on the person who is the accused, whether he should be given the FIR or not. The law is silent on that. It is through the case laws that the accused is also provided with the FIR, but the law is again silent on it. The victim is provided with the FIR, the informant is provided with the FIR. Why? Because there can be two different persons. Suppose if I see some offense, if I see a person committing rape on girl, why? I was passing by through some shop and I see this. Why was shouting? So I'll go to the police station and report the offense. I am this person. I am M, and I've seen a rape being committed to Y. So to this person also, the copy will be given, and to me also the copy will be given, because both of us are very important witnesses. This is actually the victim, and this is actually the person who's informing the offense. So there can be two different persons. One is the victim and one is the informant. Earlier, the law was silent on the provision of victim also, but the same case which I'm going to tell you today is talking about the victim also, but then that is considered to be added in the BNSS, but not the accused. If the accused would have been added here, then it would have been an exhaustive list. Now, coming to the next provision, this is something which is not there under 173, clause number 3. This is a new clause. Don't be scared, guys. Only chapter 13 has so many changes. So just to reform these FIRs and the procedures and the loopholes in filing the FIR and everything, these kind of provisions are added. So otherwise, the whole CRPC is very much same to the new BNSS. So if you read this, without prejudice to the provisions contained in section 175. Section 175 is procedure for cognizable cases. On receipt of information relating to the commission of a cognizable offense, which is made punishable for 3 years or more but less than 7 years. That means 3 to 7 years. In between, it can be 3 years, 4 years, 5 years, 6 years, but not, it can be 7 years also, but not more than 7 years. The officer in charge of a police station may, with the prior permission from an officer not below the rank of DSP, Deputy Superintendent of Police, considering the nature and gravity of the offense, proceed to conduct preliminary, this is now inquiry, to ascertain whether there exists a prima facie case for proceeding in the matter within a period of 14 days, or to proceed with investigation when there is a prima facie case. Now, earlier, there was no such provision. So what used to happen, that there was like immediately, if the police thinks that there is no case of, like, there is no need of investigation, the police used to file the closure report. Then if that happens, or the police used to, send back to the magistrate. So if that happens, a lot of cases were false also, and then the lot of cases were true also. So there was a lot of confusion earlier. So now they have made this mandatory provision that between 3 to 7 years, the police can seek the permission of deputy superintendent of police. That means above the police officer in the police station, there is DSP. The police can take his superior's permission so that he can conduct a preliminary inquiry to see whether there is a case or not within 14 days, or he can proceed with the investigation where there exists a prima facie case. This is just for 3 to 7 years for smaller offenses which are cognizable, but the punishments are 3 to 7 years. The police has a power to conduct the preliminary inquiry, and it is a may provision. It is a may provision. A receipt of information cognizable which is but less than the police officer, officer in charge of a police station may. So it depends upon the police officer. It is not mandatory. The inquiry mentioned here is not mandatory. The preliminary inquiry. This inquiry is not that inquiry. This is an inquiry which has to be conducted by the police officer only. That is why, to again restrict the power of police officer, if there should not be the days mentioned somewhere, if BNSS is giving the police powers considering the false cases, then it is restricting also. So within 14 days, the inquiry should be conducted by the police officer to ascertain that whether there is a case or not. And if the police thinks that yes, there is a case, he will directly proceed with the investigation without even conducting the inquiry. So, ma'am, inquiry is to be done by the police officer. See, this is a new law. So this is, you can say this is a word which is mentioned for the very first time, and since the spelling is different, you can differentiate it like that only. So there is like no other inquiries by the police officers. This is the only inquiry which a police officer is conducting. Enquiry, not inquiry. This is, you can consider it as like ascertainment of a case, so that the police officers also do not waste their time in false cases. This is very similar to what the older CRPC had. I think this was 154.3, which is made 154 173.4 now, because this clause 3 is added. This is very important. Very, very important. So now, any person aggrieved by the refusal on the part of officer in charge of a police station to record the information referred in subsection 1, basically, if the police officer denies to record the FIR, even if the FIR was very complete in its whole sense. The aggrieved person may send the substance of such information in writing and by post to the superintendent of police concerned, who, if satisfied that such information discloses the commission of a cognizable offense, shall either investigate the case himself or direct an investigation to be made by the police officer subordinate to him in the manner provided by this Sanhita, and such officer shall have all the powers of an officer in charge of a police station in relation to that offense. Now, till here, the old law was finished. Failing which, such aggrieved person may make an application to the magistrate. So earlier this was implied. पहले ये understood था. The law was silent on it. This was very understood that if understand the just a second. Understand the sequence here. If an FIR is filed, then the police starts to investigate the case. This was the whole investigation. But what if a person comes to lodge an FIR and the police refuses here? The police refuses to lodge an FIR. The person can go to the superintendent of police. Not even go. Send the FIR in writing and by post to the superintendent of police. He can either direct the further investigation or he can do it himself. Because he is also a police officer, he can do the investigation. He's not a court. But if he does not do that, if he also refuses, then it was very obvious before also, then the person will go to a magistrate to file a complaint. This is where the complaint cases are usually drawn from. Then the magistrate will see the complaint, conduct the complaint proceedings under Chapter 16. If he dismisses it, finished. If he approves it, he takes cognizance on a complaint. That is why I explained cognizance before starting with investigation.
Ma'am, so one doubt. Ma'am, this particular part was not there prior to the VNSS. Ma'am, so that means 2101A was also not there?
2101A was there. This was silent. That was obvious that if the superintendent of police refuses, the person will directly go to the magistrate and file the complaint. This was silent, but this was deemed to be like this was the procedure before also. There is no change in the procedure. It is just mentioned here. Now,
Okay, ma'am.
now one thing is not mentioned here. If the magistrate dismisses the complaint, then what? Or if the magistrate refuses to file the complaint, even before these proceedings, then what? This is not mentioned here. What if after 10 years a new law comes? I hope it does not. I know the problems we are all going through. So what if after 10 years a new law comes into picture with a more complicated name, and then if the magistrate refuses to file the complaint, and then it will be mentioned here that what if the magistrate also refuses to file the complaint, then comes the High Court inherent powers. If this is also mentioned here, then also it makes no difference because this is the whole procedure. If the magistrate also refuses, then the person can go to the High Court, file a writ, and the High Court has the inherent powers under section 482 it was, and now it is 511, I think. 482 का है 528. 528 of BNSS, which is the inherent powers of High Court. The High Court can have inherent powers which is not even mentioned in the code. The High Court can have those powers to prevent the abuse of the court, to prevent the failures of injustice. All those mentioned points are mentioned under section 528 now. Clear? So this is not even mentioned in the section, but this is the procedure. Okay? तो ऐसा तो नहीं है कि अगर this is not mentioned, then writs are also not there, inherent powers are also not there. This is not something new. This was actually in process, but what is new in FIR now is jurisdiction removal, which is very new. Electronic communication, which is new. Signing of electronic communication within 3 days, and then clause 3, which is very new for offenses between 3 to 7 years, preliminary inquiry by police officer. This is a May clause, and this inquiry has to be finished within 14 days. This is the gist of FIR if you compare it with the new law. Now answering the questions very quickly, like we did yesterday.
मैम
Yes,
मैं वो इलेक्ट्रॉनिक एविडेंस के ऊपर क्या लिखा हुआ है FIR
3 days.
उसके ऊपर मैम
Jurisdiction removal.
ओके मैम
First point, like make stars in your notebook. It should be descriptive and not cryptic. Cryptic means what? WhatsApp पे आता है ना? The messages are cryptic. मतलब the messages are not explaining the whole information. So what does it mean? That means the information should be descriptive. ऐसा कि नहीं, the one example which was in the chat box, A killed B. If you call and inform only this, FIR will not be accepted. The police officer will consider the seriousness of the offense and go to the place of offense, but he will not be, lodging the FIR out of it. He will be giving the information himself. And it will be an information case, not the FIR case. The FIR should be descriptive and not cryptic. It should reveal. Anju, please mark this because you were confused. It should reveal cognizable cases. Cognizable cases are mentioned in Schedule 1. Yes, Parvez. Let me pick up my charger also till the time you ask your doubt. I'm listening. Please. Ask.
Ma'am, the case where you mentioned about the refusal of the officer to register the FIR, ma'am, in such a case, the FIR can be then sent to the SP. Ma'am, but will the officer that has declined the registration, will he face any consequences for the same?
See, just a second, I'm coming back. Yes. So the police will not, like, this is not even mentioned in BNS that what will happen to the police if he does not lodge the FIR, which should be lodged. So it is not mentioned in the code or in the law anywhere, but yes, the police acts of every different states, the police acts are different state-wise, like the local laws. So they mention some kind of liability, or like if they do it 2 or 3 times, the not following the duty properly, then the police can be made liable. Otherwise, not under the central laws.
All right.
Okay. It should reveal cognizable cases. Yes, it should reveal cognizable cases and not the non-cognizable cases. I'll let you know. Okay, Rajat, please tell me what happens in a non-cognizable case. पता तो चले कितना समझ आ रहा है.
Ma'am, in a non-cognizable case, first the NCR should be filed. Then the process of police, if the magistrate, if
NCR
the
is sent for
magistrate,
permission to the magistrate. Yes,
yes,
correct.
ma'am. And
Yes.
if the magistrate said yes, then the process will be as same as in the cognizable case, and if not, then it will be different.
Awesome. See, now, unlike everyone is understanding, even the students who are silent, like I consider students who are not speaking in the class to be uh on the same ground. Like I was one of the students who never used to speak in the class. I was very shy. So I can consider those students, like I do not differentiate between those students. I picked up Rajat's name just because I wanted to know whether I am explaining the concepts right and whether it is going in your heads or not. So this is one of the very big disadvantages of online medium. I was feeling till now that only 2-3 people are understanding, those who are speaking, and nobody else is understanding. So I'm really happy if everyone else is understanding. Venkat is not even attending the classes who had the doubts. Otherwise, everyone else is understanding. Okay, so it should reveal cognizable cases. Cognizable cases are under Schedule 1 and the police can arrest without warrant. Anonymous FIR. Anonymous FIR is not an FIR. For example, if I was in a club and I called the police that, you will relate to it, that Jessica Lal was killed by Manu Sharma, which actually happened. This is a reality. A person from the club only called the police to inform this. But he did not mention his name. So he'll not be called as a prosecution witness. And if he'll not be called as a prosecution witness, it will not be an FIR. The police went to the scene. He found Jessica Lal dead, and then the police registered the case. Why the person did not tell his name? Because for obvious reason in this case, his influential background. If he would have told his name, or if he would have, like, if it was a woman, I'm not sure who called because nobody knows it. अभी तक वो होता नहीं यहाँ, because you know Manu Sharma's family. So this is the perfect example of an anonymous FIR. FIR sets investigation into motion. But here comes a catch. If an FIR is filed, investigation starts, as it is mentioned, FIR sets investigation into the motion. In between here, if again a person comes with a lot of other information, then also the FIR can be filed. After an FIR, even after commencement of investigation, in between investigation proceedings, this is all investigation. Somewhere here, again the FIR can be filed by the same informant or by the new informant, whatever the case is. FIR is only supportive in nature. The legal word for supportive is, why I'm using supportive, just to make you understand the meaning of this word. Corroborative, which is used under Indian Evidence Act a lot. In nature, in the trial proceedings. The copy of FIR can only be given to support the testimony of the prosecution witness, not for contradiction, not for any other use, just to support the testimony. And supporting the testimony means, if, for example, if prosecution witness says that I have seen A killing B and I have filed the FIR, I am the mother of A. Sorry, I am the mother of B. My daughter is killed. I have seen A killing B. The prosecution witness is claiming that, and then she has come to the court. The mother has come to the police station and filed the FIR. Now mother has come to the court. Now mother's testimony can be used to corroborate the testimony of A. Corroboration means either impeaching his credit. Impeaching the credit means to disregard what he's saying. Obviously, A will deny. To impeach his credit, there is an eyewitness, which is B's mother, who's B's mother. So your statement is disregarded. She has seen you murdering B. Then to refresh the memory. Yes, I'm coming to you, Nimisha. Refresh the memory. Refreshing the memory means FIR cannot be just this, that A killed B. Obviously, the mother will explain the whole incident, that I was sitting here, my daughter came from here, A came from here, from this weapon, A killed B. To recreate the whole event, and to refresh A's memory, the copy of the FIR can be produced and used. Yes, Nimisha.
Ma'am, can you please give an example of the point right about this one? Like when a FIR can be
Yes.
filed after an FIR is already been filed.
Okay, so suppose this example only, the mother explained the whole situation, that my daughter was sitting behind me in a sofa set. We were drinking tea. Then A came from one other room. A is our servant. I'm just building up a story. He killed B, and with a knife. He was using it to cut the vegetable, and he killed B with the same knife. But this was the FIR by the mother. At this time, at this place, I live here and this is my house. Everything is now valid to file a logical FIR. The FIR is filed, the investigation is started. Suppose the neighbor come to the police station again and tell the police that we were seeing the whole incident from our window. It was actually that B instigated A, and B told A, B was fighting with A a lot, that he was not doing his duties properly, and B was instigating A, and in between a sudden fight, A picked up a knife and killed B. New discovery of facts, new FIR, new information, new informant. If suppose in between this, the mother only comes back and she says, I was very scared, I did not even remember, I was not in my senses, that I was looking at my, like I was sleeping, I did not hear the voice, I came out from my room and I saw A and B fighting. I did not see A and B fighting. I just saw that B killed A. Now I remember B was killing A, right? So sorry, A killed B. Now I remember that I was hearing some voices also. New discovery of fact, new FIR. So this is all about in between. Even after in between the investigation, the FIR can be filed.
Ma'am?
Yes.
Ma'am, actually, I didn't understand this part regarding anonymous FIR. Ma'am, you said that if the information given is anonymous, then FIR cannot be filed, right?
See, if you call a police station now and tell them, and actually it is happening that a person died because B killed him. Okay, you call them and you do not tell them their name, but tell your name and you disconnect the call. You just tell them that the police will obviously ask, kahan se baat kar rahe ho, from where are you calling? You will tell them I am calling from location X nearby to hospital Y, just for an example, your address. And you just disconnect the call, you don't want to tell your name. This information will not be an FIR. This is an anonymous FIR, which is not an FIR. The police will go to this location and see the case and then give the information to the magistrate. This will not be an FIR. Okay, that's all.
Okay, ma'am. And ma'am, that would fall under 2101A.
No, that will not fall under 2101A. I was about to cross it. That will not fall under 2101A because any information received apart from the police officer. 2101A mentioned, the 2101C mentions it. Sorry, it will not fall under 2101C apart from the police officer. This will fall under 2101A, not C. I was about to cross it.
Okay.
Not C. Yes, it will be a police report. Information, not a police report, but information given by the police.
And ma'am, are there any cases where FIR would not be considered as a corroborative evidence or supportive evidence? Or is it like in all cases it will be considered as a supportive and valid evidence?
Obviously, if the FIR is validly lodged, then it will be used by the police officer. वैसे भी the situation of the country, the police is ready to frame the case even against those who are not even guilty. So police will definitely use the FIR. There will be no such cases. I don't think so. The police can be losing upon such an important evidence.
Okay, ma'am.
Last point for today. The investigating officer, in between the investigation, can he himself file the FIR? Can somebody tell me?
Does this mean that the investigating officer can be a deemed complainant?
Not really, because FIR is made in the police station only. This means that investigating officer is an informant now. Can that happen? Generally, no. Because obviously, biasness will come into the picture. If the investigating officer himself has discovered some facts and he himself becomes the informant, then how he'll be going to conduct the unbiased investigation? So generally, no. But yes, in one case, reverse burden. What is reverse burden? You drive a car straight, you drive a car in reverse gear, then reverse. It is a kind of reverse position. So the same thing is generally the burden of proof, the proving the guilt is on prosecution because he is coming with the case. So person who is filing the FIR, the police team, the team of prosecution is duty bound to prove the guilt of the accused. If they failed, the accused will be acquitted. If they are successful in proving the guilt of the accused will be punished. It is not the accused who should be proving his innocence. But in case of reverse burden, for example, POXO. What is POXO?
Ma'am, sexual harassment against children.
Children. This is one of the 2012 Act. So that is designed to punish the offenders committing sexual offenses against children, which is, you can understand how grave it is. So that is why the burden of proof is on accused. If an FIR is filed that I have seen a person committing rape on a child of 6 years, then the accused will have to prove his innocence. This is a case of reverse burden. In such cases only, POXO and I just know two grave acts of reverse burden, NDPS and POXO. These two acts are the cases of reverse burdens. Reverse burden, now you understand, where accused has to prove that he is not guilty. In such cases only the investigating officer can be the informant himself.
Can you explain that point once again, ma'am, about the reverse burden?
So generally what happens is, in all the cases, for example, A committed the murder of B. This was informed by person X. He's the informant. B's family, police, everyone is the team of prosecution, including X. So they have to prove that A has actually committed the murder of A. If they fail to prove that, A will be free, acquitted. Generally, this is the case. Burden of proof is on the prosecution. Burden of, when you'll understand Indian Evidence Act, this is one of the major principles of Indian Evidence Act. Burden of proof is on the prosecution only in criminal cases. But there are some cases of, yes, in criminal cases, that's what. So in reverse burden cases, for example, the special acts, POXO, the burden is on the accused that he is innocent. If there is an FIR against an accused committing an offense under the POXO, Protection of Children from Sexual Offences Act 2012, or NDPS, these are the two acts of reverse burden. Then these are not only the two acts, these are the examples of two acts of reverse burden. Ma'am, the reverse burden of proof is settled in any ruling? No. Generally, there is a presumption of innocence, but in some cases of such POXO, there is a presumption of commit. Yes, exactly. Right. So in such cases of POXO, the accused has to prove that he is innocent and he has not committed the crime. So it is not on the prosecution and it is not on the police officer per se. The investigation and everything is different in POXO and NDPS. So in such cases, the police officer can be an informant himself. Otherwise not. Last thing before concluding the class, just write the name of this case law and then FIR will be done. We'll be beginning with statements during investigation from tomorrow. Youth Association versus Union of India 2016 and Harendra Rai versus State of Bihar 2023. This is important because this is the landmark case where it was held that under 173 clause 2, the copy of FIR, yet again it was held in 2023, copy of FIR should be given to the accused also. Along with, please name those two persons who are mentioned in 173. Can someone? Along with?
The victim and the informant.
Informant and victim.
Perfect. Victim and informant. These are the two noteworthy cases considering the relevance of latest cases. Landmark is Lalita Kumari only, and this is the latest cases. Lalita Kumari will do tomorrow in the beginning of the class, and then we'll be starting with the statements made to the police officers. Just one thing, cross FIRs was the last point. Cross FIRs, in case A also files the FIR against B, B also files the FIR against A. Two persons caused grievous hurt to each other. A also filed where A's bone was fractured and B's eye was wounded. So in this case, A also filed an FIR against B, B also filed an FIR against A. In case of cross FIRs, no FIR will be quashed. Nothing will be cancelled. Both the FIRs will be considered valid. Police will conduct investigation. On the basis of both the FIRs. And then there will be one common police report. For both the FIRs in the same court. Multiple FIRs. A, B, C, D. All these areas, the FIRs are filed. अब तो ऐसा ये होगा नहीं because the jurisdiction is फिर भी हो सकता है, but that for one single offense multiple FIRs are filed. Every FIR will be quashed by the High Court under section, was it 523? The 528. Inherent powers. If they are different states, for example, this is Maharashtra, this is MP, this is UP, this is Bihar. इतने सारे states में file हुए, then 528 will come into picture. High Court will score. High Court will quash the FIR.
Ma'am, 528, right? 520?
528, yes, 528, 528.
All right.
Ma'am, reverse burden हो गया. Generally, there is a presumption of innocence. Ma'am, even in PMLA, reverse burden is there, right? Yes. Ma'am, cross FIR and counter blast are same. I am not aware about counter blast. I'll confirm it tomorrow. PMLA is also one of the reverse burden case acts. Yes, I was only able to recall POXO and NDPS. FIR is done, guys. We'll be starting with the procedures and the statements from tomorrow. Any doubts? If multiple FIRs are filed before the states, different states also, and if multiple FIRs are filed before different areas, then all the other FIRs will be quashed by the High Court under the inherent power, exercising their inherent powers, and one FIR will only be considered valid, whatever the High Court thinks fit. Ma'am, can an FIR filed again on appreciation of new evidence after cognizance or police report? No. Cognizance is a gateway to trial. So once a police report is filed, investigation is done. And once investigation is done, no chance of FIR. If there is a new discovery of fact, come to the court. Follow the procedure of the court on trials. You have a class in 1 minute, guys. I'm really sorry. We had to cover this FIR today. So I took 2 hours. Let's start the procedures from tomorrow. Okay?
Yes, ma'am. Thank you, ma'am.
Thank you so much.